very much, Nasir, for okay. So thank you very much, Tina, and thank you very much, Nasir, for accepting this invitation. And I wanted to have you because I saw the book and it caught my attention. I'm dealing on this issue, and in fact, I proposed some similar to this project about the regulation of online platforms, and I thought, okay, let's go with Nasir and propose to have a conversation with him on artificial intelligence challenges. And you wrote about the civil liability because it's very interesting for our region. And of course that I read your book. Of course, I am not a civil lawyer, but from the perspective of harmonization of legislation and so on, we all Western Balkan countries are in the similar path. So need for the harmonization of the legislation. And I'm just providing a short bio because we academics, beyond our short bio, we do a lot of other things, but just an overview of your activity. And you are an assistant professor at University of Sarajevo, and you have been graduated from Faculty of Law of the same university in 2016. And then Nasir obtained a Master in Law degree in International Business Law from the Central European University in 2017. And in 2023, Nasir defended his PhD on the artificial intelligence and civil liability at University of Sarajevo. And recently, as I said, his PhD has been revised, of course, and published by the well-known publisher, Springer. And later on, maybe Nasir can show to the speaker, and if you have access or interest, you can read it because it's very important and also useful. Nasir has experience in the fields of media and telecommunication law, civil litigation, intellectual property law, commercial contracts, and regulatory compliance. And currently, his research is on the intersection between private rights and tech law. He is a regular consultant in media law and digital policy project organized by the Council of Europe, European Union, Organization for Security and Cooperation in Europe. And furthermore, Nasir has advised the Council of Ministers in Bosnia and Herzegovina in matters of the Council of Europe's Committee on Artificial Intelligence work. And it's an honor for me to have Nasir here, and let's hear his talk and then to have, of course, a question and answer session, because it's very important about the issue of regulating artificial intelligence in our countries. So far, Bosnian government has started to discuss these issues. I know from our colleague in Serbia as well, they have discussed this issue, whereas in Albania, this discussion is a little bit in limbo. Nasir, you have the floor.
Okay, thank you so much. Good afternoon. I'm very happy to be here. Thank you so much for having me. I always feel a bit embarrassed when I hear these words about myself. And usually they're like the person who introduces a speaker reads from the bio. So I'll take this note and send shorter bio next time when I have a talk. Thank you so much for your kind introduction. And I also, and thank you for reading the book. I hope that it wasn't that boring for you as not civil lawyer. The reason I decided to write about this topic is because I found at the moment when I was starting to discuss this idea and thinking about it and writing about it, that actually it is a bit neglected in this part of the world. Typically, at least my impression was at the time, and still is to a certain degree, that there are certain fields of policy and then law, which in this part of the world, the Western Balkans and in the region, and actually I think there's a broader phenomenon that can be observed beyond Europe, which says that you let the big guys regulate tech and then you small guys take over. And I was under impression that this is what is going on when it comes to AI, because at the time it was beginning of 2020, there was COVID, there was huge shift to digital technologies. My understanding was it was the time of great confusion, and nobody actually knew what they were supposed to do. However, everybody was aware that something should be done. And at the time, that was the time of the consideration by the EU as the leading jurisdiction in the world of how to approach AI and how to regulate it. Back at the time, we didn't know that AI Act is going to look like it looks today, and that a framework of liability is not going to be like it is today, which is basically which is, I believe, underwhelming for many scholars who observed this over a year compared to what was promised. So at the time, I realized that, okay, I understand that perhaps capacities to consider these problems are limited in the governments which do not have such extensive resources when it comes to experts, material resources, time, or even more pressing issues. However, this is not going to be something that does not concern us, because AI and tech is already here and we have to live with it. However, if we live with it and we wait for others to adopt the rule that we can take over, then it is going to be very hard for us to understand what the rules should do and how to apply them. And even I believe that in the long run, there might even be some worse consequences, such as lack of awareness of general ideas behind certain laws, which were supposed to implement policy. That's at least the way I see it. So I actually dealt with a very narrow issue, which is now only part of the discussion about law and AI, because law is, I think, different branches of law, perhaps without exception, are interested in AI, and because AI is so pervasive, so is a game changer, right? So in a way, my focus was very limited. So today, if I'm allowed, I would like to provide you a short overview of what I think about AI liability in this region, as well as of general approach to regulating AI and Southeast Europe, Western Balkan, and regulation actually in Europe in general. So basically what we have in Europe, that was the focus of my interest in the European Union. There was this split of powers, where some member states held powers in certain regards and the EU had powers to legislate in others. So when it comes to safety standard in general, when it comes to regulation of technology, the EU would typically regulate safety. So it provide different type of safety standards, whereas liability would be typically left for member states to deal with. There is some EU work in field of liability. However, it is very limited compared to safety standards. And the initial EU approach was, okay, let's discuss safety standards, which materialize into what is today AI Act. First of all, and there are other instruments, but AI Act is the leading one. And let's leave AI for member states to discuss the main questions of liability, or the liability in total. However, what allowed me to do research in liability, given that there's this fragmentation in the EU as well as on the continent, was the fact that European states have similar principles and concepts on which they base their liability rules, liability frameworks. So actually that was very helpful. There are, of course, exceptions, there are differences. However, similar concepts and ideas can be found around the continent. And there are some typical tools which are known to lawyers, and I believe also those who are not lawyers, because they tend to be even intuitive, and they are here for millennia. Some of the concepts are here from the Roman law or even before. So traditionally, liability law is designed to be future-proof and technology neutral, meaning that it should be flexible to the extent that it can cover different types of accidents, which can be caused by different types of human innovations, different types of new activities, which could not be foreseen by lawmakers at the time of the drafting of the law. This is what future-proof means. Technology neutral also means that when it comes to different types of application, different type of activities, the law should be agnostic, and it should be able to cover different types of, it should be comprehensive. However, in case of AI, we actually see that this is not so easy, even though this system worked for so long. The reason is because the AI, I believe, undermines some of the fundamental tenets of the law in general, policy as well, and this is something I believe that we are all aware of, even without my presentation, right? It is transformative. Typically, when you discuss liability, you have a couple of concepts which float around, such as the fall-based liability, vicarious liability, product liability. And courts around Europe are very familiar, and abroad are very familiar with these concepts. They're familiar with how to interpret these different standards, how they can evolve, and typically they are very well-versed, actually well-oiled machines that tend to work for a long time. So what is so new about AI and liability? There are obviously some I believe, there are some very obvious things that I believe can be pointed out, which is the AI is the first thing in human history, as far as I know, that has the ability to change over time based on its previous experience, and it has certain degree of autonomy and the ability to adapt to previous circumstances, and to be active, to make a decision and either execute a decision without human involvement or with less human involvement than typical human inventions. Okay. Also, it can be very complex to the extent that we cannot really understand it. So this is referred to as black box and opacity of an AI system. And this together poses a great risk to legal systems. When you think about it, do we have certain entities which were used by humans, but who were to a degree autonomous, or who were completely autonomous? This is a question that was posed by many scholars and still is posed by many scholars when it comes to when they try to find analogies with AI. And there are answers such as, okay, we have animals. Animals have certain degree of autonomy. We cannot really control their behavior. However, they typically serve humans, or they're owned by humans. Humans have them as pets, etc. So humans, because they have the highest control, or any type or some degree of control, they should be held liable for behavior of these animals. So in concert, it was very interesting to understand these characteristics. And over time, I believe that scholarship and later the law in European Union developed, first of all, by recognizing these characteristics. So there are many authors, as well as many papers published by the different governments and supra-governmental institutions, which tends to categorize different characteristics of AI, and they try to use them as a starting point for developing different policies, different laws. I believe these four at least are typically found in every such classification. However, to define AI is a very hard task, because any of these notions can be understood is not actually self-explanatory, at least that's what many legal scholars thought. Because what is actually autonomy? What is self-learning capacity and complexity? And the law requires a certain degree of clarity. Even in computer science, so the people who actually create AI, there is no consensus concerning what this technology consists of and how it can be defined. So it was very hard to reach a legal definition. And road towards legal definition, which was eventually accepted in the EU, and it is today in the AI Act, was actually not that easy. And today, when you read the definition, which I'm not going to do right now because I believe it wouldn't be the main point of this presentation, and I suggest you do if you're interested, you can find also some terms, some notions, which I believe are not very self-explanatory, and you can understand them in different ways. And at the moment, the EU is trying to explain what it wanted to say in the AI Act, so it currently publishes different documents explaining what the AI actually is, even though there is a definition in the AI Act, etc. So this is an ongoing process. The main point, which I believe should be mentioned, is that AI, and this is a recital of the AI Act, is a system with a key characteristic. The key characteristic of AI systems is their capability to infer, meaning that they should be able to make conclusions, right? And again, we can actually ask the question, what is a conclusion, and how to reach it, and how to understand it as a legal notion. But this is something that perhaps we shouldn't go into right now. So the question was how to treat liability, because we have different. We have a new player in the town. We have AI, which is something I believe without precedent, and we have actually system which relies on borderless character of data and communication with different systems. It learns from its own experience, but it also has the ability to learn from other AI systems' experience. It can be argued that the more data there is, which I believe is not a great argument, by the way, but I should mention it, the more data is available, the better AI will be. And if we fragment the market with different liability rules, it will be harder for European AI to be as good as it can be. And moreover, in a broader context, the Europeans were concerned that other jurisdictions, I'm sure everybody here is familiar with this China, US, the EU, like trilemma when it comes to regulation of AI. They were concerned that they will lag behind because the European Union and the Europe in general lags behind China and the EU based on all, I believe, relevant statistical parameters when it comes to development of technology. However, when it comes to the development of the law concerning AI and digital technologies, the EU is, I believe, at the forefront globally. So these were some of the concerns which went beyond the techniques of legislating. And I believe they were but I believe they were very relevant. So, yes. It was interesting to understand what the EU did in trying to understand one, I believe, policy question, which was, okay, in case when we have an autonomous entity, which has the ability to act without ultimate or complete or decisive control of humans or even manufacturer, how to allocate liability, right? I'm sorry. This question is actually a very hard one. It is, as I said, I think it's more than law. So there's this traditional philosophical dilemma called the trolley problem, which is depicted on this image, which says if this trolley keeps moving, it is going to hurt or even murder 5 persons. However, if a human who has the certain control uses its powers, then it can change the direction of this trolley, and instead of 5, only 1 person can be hurt or murdered. So the question is, should human do that? And we have this dilemma of how to understand justice, and we have this Kantian understanding and different utilitarian understandings, so the ontological and utilitarian. So this is a philosophical problem. And as far as I know, the law does not have a clear rule on what humans should do in this situation. If we tend to imagine a scenario in which AI has the ability to decide in such case, I believe we have a pretty big problem. Should we try to adopt a rule and which needs to be based on a philosophical understanding of justice, and to provide a rule for AI to behave in a certain manner? That would mean that we need to solve philosophical problems, or that we need to rely on companies who are going to develop these trolleys to have their own view of what is justice, and to code that view into the algorithm which will control the behavior of AI in such situations. So there are many problems concerning many problems beyond the law. And how to approach this problem. I believe there was a bit of a roller coaster in the EU, which is pretty interesting. So first, the EU said, okay, let's not try to decide whether we should allocate liability to designers, manufacturers, developers, or those group of persons who participate in creation of AI on one hand, and on the other hand, on those who tend to use AI. So different types of users, different types of users or even owners, right? Those who do not create who do not participate in creation, but they participate in use or they own. So the EU said, let's not do any of those options. Actually, we have precedent in the history. And some scholars argue that, okay, in the Roman law, there was this concept of slaves. Slaves were humans. However, the law didn't recognize them as humans. They were things. They were treated as other things with some exceptions. And those exceptions are, in case they cause harm, there was this concept of peculium, which was a certain quantum of property which can be used by, which was owned by a slave who was not a person, and that slave could compensate for victims of slaves' wrongdoings. Essentially, this means that this concept basically provides for a limited liability of owners of a slave. So the idea was, okay, we used to have it before, and today, even in some company laws around Europe, there is this concept in the formation, in the phase of formation of a company, so limited personhood in a way. So let's try to create electronic personhood. And the EU Parliament actually, in the resolution of 2017, championed this view. And fortunately, they abandoned it because there were several problems. The main one, I believe, is that it shields humans, and not only humans, but also other types of persons behind AI. Basically, the message, the incentive that persons who create and who use is that they can be, to a certain degree, reckless because their liability is going to be limited. There are other problems as well, more technical, such as who is going to provide this quantum of property, and there are, I believe, problems which are not legal, such as the problem of who should be treated as persons. Should humans and human-run entities, such as companies, be treated in the same way as non-human entities, such as AI? So eventually, this idea was abandoned, and the second idea was proposed 3 years later, 2020, the EU Parliament again, and the idea was, let's treat persons in relation to AI as operators. Some of them will be backend, some of them will be front end, and based on the actual degree of control they have over AI, they will be liable. However, from a perspective of an injured person, so the victim of an accident, it doesn't matter because they will be jointly severally liable. This was, I think, very good idea. However, it was abandoned. And a couple of years later, we have a new approach, which was a bit underwhelming, which was based on the idea of let's update an old instrument on product liability, and let's create a new directive which was supposed to deal with default-based liability, because product liability is one type of strict liability in different types of national legal regimes. I'm not sure if there's correlation or causation, but after the inauguration of President Trump, the EU actually abandoned the idea of adopting the AI liability directive. And I think sometime before they adopted the amendments to the updates to the product liability directive. So at the moment, what we do have on the EU level is the updated version of product liability directive and a message that member states received, at least this is my understanding, that they should legislate if they want to legislate on their own. So basically, what we have is some sort of a shift in the policy making of the EU in the last 2 years, and especially after the inauguration of President Trump, meaning that the countries themselves have more jurisdiction than a couple of months before, or they will have to try to have their own national responses to this issue. When it comes to Western Balkans, I tried to ask this question and to ask, what is this actually something that we can participate in? And unfortunately, at the time, the scholarship was very limited in this area, and governmental actions were absent. That was 5 years ago when I started doing research on this topic. In the meantime, countries around the Western Balkans, with the exception of Bosnia, adopted their AI strategies, which per se is not a law, at least in countries that I observed. So I could be wrong on this one, but they were typically adopted by the executive bodies, and they were some sort of policy choices and they declared orientation and some priorities of states when it comes to investment in AI, when it comes to protection of risks generated by AI, etc. But the country where I come from, Bosnia and Herzegovina, failed to pass such strategy. either on the state or even on the lower levels of the government. So basically, there is no strategy at the moment. I believe that there should be one. When it comes to the question of liability, what I found, because I studied the law of obligations, which is, I think in different forms still exists throughout the former Yugoslavian states. Remarkably, I believe it is a future-proof and technology-neutral instrument which provides more freedom to courts than in case of many, for instance, BGB, so German Civil Code, and other civil codes around Europe, because it provides with very broad definitions of, for instance, manufacture or defect, or provides no definition of certain notions, which I believe is not a bad thing per se, because it allows for creativity and adaptation by the courts. My idea also, and I think that when it comes to the question of liability, we should solve the problems which exist. And there's this notion called normative optimism, whereby people tend to think that some problems will be solved by adopting laws. And sometimes that is correct, but sometimes I think that you need a subject matter so you need a problem, you need a fire you need a problem to solve a problem, right? I don't think that we actually have a certain a problem of AI liability to the extent that it requires comprehensive revision of civil codes anywhere so far. I tend to advocate a sector-specific approach where possible. So basically, if AI emerges in, for instance, medical sector, that we need to focus on the specific sector and to realize the specific risks and to adopt rules if necessary, or to interpret rules which already exist in a different way. However, if there is no problem in other sectors where AI operates, then perhaps we shouldn't actually deal with it, because AI has this ability to change over time. And as a technology which is to a degree unpredictable, it would be probably, we would probably make a mistake if we tend to behave like we understand it completely right now. So perhaps I can stop right now with this introductory presentations, and yeah, I think I will stop right now.
Okay, thank you very much, Nasir, for your presentation. From the audience, is there anyone who has a question?
Yeah, it is awkward to be a moderator when there's no questions. You need to write those questions down and pretend like people are interested.
There are questions, but just yes, Peter.
So I'm sure if you can see me or not on here, but okay, hopefully you can hear me. If not, yeah, thank you very much for very interesting talk. Now, what I wanted to do really was just sort of maybe to tease out some of the, let's say, underlying kind of questions here, because first, I suppose my first question is, okay, if we're talking about liability, we're also talking about harm. So I suppose if I wanted to change the perspective slightly, is to say what harm does this civil framework respond to? And then I suppose my next question is, in terms of if we overcome the problems of establishing liability, what then do we think about in terms of, well, if you want to put it like that, you can't speak criminally because it's not punishment, but if we're talking about it in terms of civil remedies, what are we also considering here too? Because in a way, if you have a framework of regulation, you also have to consider, let's say, if there is a harm, okay, civilly speaking, how then do you respond to this in terms of the type of, okay, once you establish liability, what type of liability you're going to impose, in the sense of, is it just damages, or because of course, if we're talking about AI, let's say AI not being, let's say, conventionally human, the type of harm is not strictly the same as a, let's say, a human imposed form or a corporate form of harm, is it? I mean, I ask this not understand me. It's not a criticism at all. It's just to try to understand that, let's say, the foundations of this.
Well, thank you so much. I think those are wonderful questions, and they are not so easy to understand, at least for me.
No,
So,
and I'm not suggesting they are.
okay, so the first question is harm. Actually, in my research, I found there are actually different understandings of what laws should do. So when it comes to liability, we have very specific calculable types of harms, which is actually a pretty restrictive view. So the law, at least civil law, doesn't deal with harms which cannot be, which are not calculable, or for which we cannot at least try to pretend that we can measure in terms of money. So actually, it's pretty restrictive. And so this is the first point. So these are not all types of harms. I believe that there are many types of harm which are probably even more serious because they're not individual, but very often collective and very often not easily noticeable or not easily cured. And they are not there. They cannot be dealt with civil law or perhaps not even law. So this is the first point. When it comes to understanding of liability framework, however, what I dealt with was only one side of a coin. I believe that safety standards and prevention, actually, so ex ante type of measures are probably more important than ex post, which is liability. So prevention. And the AI Act is an instrument which was supposed to provide prevention because it classifies different types of risks and of AI systems based on the risks they pose. And there's a huge discussion of whether it does it well or not. But this is the idea behind. And if the higher the risk, the stringent the measures are. Some risks are even acceptable. You're probably familiar, such as social scoring, mass surveillance, etc. So yes, there is this risk. However, there are other risks which cannot be, I believe, dealt which are more complex, such as, for instance, risk of automation and loss of jobs. And this is not something that at least the government of my country, as far as I know, even discusses, which is pretty, I believe, reckless. But yeah, the other point was remedies. This is also a great point. There is a consensus that if you're a victim in a civil liability type of harm caused by an AI system, then you are in a worse position than in case of a traditional accident, because you need certain degree of expertise to prove you may need, depending on the applicable law, to prove what happened. You need expertise which may not be available to you, even if you have the money to pay for an expert who can open up the algorithm and say what happened, so they may not be available. You have legal standards which still are anthropocentric, which rely on human foreseeability and human understanding of certain events and their position based on their understanding of certain events, which could influence the events. And the AI operates in a different way. And for a party who is not a lawyer, this position is, I believe, worse than in case, as I said, of traditional accidents. So what the law is trying to do is actually, this is what the EU law does. Not completely successfully, but this is the idea. It tends to provide certain procedural guarantees to an injured party, which was supposed to provide equal footing to both parties, such as presumption of causality in case of, so typically you need to prove that, well, causality before the court. However, in case of accidents, in some cases, you will not have to do it. Or you have the right to require evidence from the other party in order to be assessed by the court and your own experts hired by you. This is not a procedural guarantee. So I'm not sure if this is going to be successful, but the idea behind remedies is that we cannot actually let the injured party bear all the burden of this very complex technology, which cannot be easily understood. And perhaps even experts may not be able to understand why it behaved in the way it behaved. So let's try to make them not have to prove everything, as in traditional sense. And when it comes to standards of liability, which I believe was your third point, excellent one, if I may notice, I failed to mention it because I thought it was too technical for this talk. But actually, yes, this is a great question, because how do we understand certain traditional notions? I mentioned fault, I mentioned strict liability, I mentioned notions such as defect. So let me go back. I have a one slide on defect, I think. Yes. So defect was understood before the changes in the product liability directive. This is actually what the EU did in order to adapt. Lack of safety, which a person is entitled to expect. And what is that? Right. So if in case we have an AI system which causes an incident, should we measure it? Should we measure it by comparing it to traditional technologies, so not AI, or to what happens if a human was there instead of AI, or what does that actually mean, right? How to determine proper safety standard. And actually, in my research, I found that the courts around Europe interpret this standard very differently. So there is no a unique approach on how to do this. I think in the long run, the idea of introducing AI is to decrease level of human error. I think this is probably going to happen, I hope. And statistically, the majority of traffic accidents happen due to human error. So even in case we have AI-induced accidents in traffic, which I hope will not be the case, at least often, I think in general, in total, there will be less accidents. So this is the idea. Okay, even if we have certain harms which were not there before, let's try to understand that as something good because we have greater benefits. And the legal question here is, in case we tend to have more and more AI systems which replace traditional systems, for instance, in case of vehicles, should we then understand standards by which we hold people as something else compared to before? Because now we have systems which tend not to be tired, tend not to drive under influence of alcohol, tend not to make human type of mistakes or human type do not have human type of flaws. So this is a very interesting question, and I believe that the social context is inevitably going to influence the way we interpret these very general standards.
Thank you very much.
Any other question?
Can I say something? If not, because
yes.
Great. Another thing that I believe is very important nowadays, which I also failed to mention because I thought it may be too much, but I believe is an interesting point to discuss, is how the countries which are not in the EU and which want to replicate or to basically to replicate EU standards, how can they do that? And today in the Western Balkans, we have actually set of problems caused by this general problem. The EU, when it legislates, it tends to legislate based on the needs of the EU. And there is this phenomenon called the Brussels effect. I'm sure perhaps you're familiar with it, meaning that many countries around the world tend to adopt their laws after the law of EU not because they have to, but because they believe the EU is a benevolent giant with a huge degree of expertise and great motivation, and it tends to adopt good legal instruments such as the GDPR, and the EU hopes that it will be standard setter globally when it comes to AI regulation. And one of the problems that the Western Balkans is currently facing, this is part of my current research, is that in fields of in fields of digital regulation, it tends to, and sometimes it even has the duty because it wants to be part of the European Union, it wants to adopt the EU standards. However, the EU instruments were not designed to be applicable on the national level only. For instance, the Digital Services Act, Digital Markets Act, and the AI Act rely on the cooperation between the EU bodies and the member state bodies. And I think it is very hard to try to substitute the EU bodies with national member state bodies because of many reasons. First of all, there's lack of expertise on the national level, which exists in case of EU Commission, especially in those small states. So yes, that's what I wanted to say.
Yeah. Yes, Emina.
Hi, Gente. Thank you so much for hosting this. And Nasir, thank you so much for this talk. I am one of those people who are very concerned about the ways AI is being used and manipulated with. And a decade ago, a group of my students did a really interesting research of how early AI was racialized, or how the human effect or the racial hierarchy, has been sort of inserted in AI and the way it delivers information about the world. Anyhow, things are changing, but AI does resemble, human condition and the geopolitical condition in many ways. And so, I understand you were talking about liability. I have a question in relation to liability. What is the cost of AI usage? Like, what is the cost on human life, on nature, on energy waste, digital waste? Are you familiar, and can you familiarize us with the studies that are offering some sort of a comprehensive approach to the cost that we are all going to be bearing with in terms of the air we breathe, the water we drink, the energy we use? And what kind of harm reproduction AI is going to be delivering to our lives?
Yes, I believe those are very important questions, and questions that are unfortunately very neglected, even though it seems that there's so many news articles, so many presentations, so many videos about it. I believe we still do not actually understand the extent to which we can suffer because of the way we innovate and the way we use technology. So this per se was not a part of my research. So I can share with you some of my insights. So as far as I know, we have several. When it comes to the creation of AI, as you said, there were many problems with how AI is being made because of who develops algorithm, who provides data, who trains AI. So for example, we know that, I think the Time published that OpenAI trains its AI systems by paying workers in Kenya under $2 an hour who were training their AI and basically grading the responses of their AI system, which is problematic on another level. We also know that I think 8 glasses of water is the cost of one ChatGPT prompt. So it's a lot, I believe, for something which we tend not to see as users or think about as users. I also know that there's been an excellent study published a couple of weeks ago whereby the big tech, so the Western big tech, basically the big American companies, tend to train their AI systems based on the data from the Western Europe, collected in the Western Europe and the United States and Canada, meaning that if you're a user in Bosnia or Kenya or Brazil or South Korea, your AI system will be will be outperformed by the one in the United States or the UK. So perhaps this is logical because of the profits or the economic system which exists, but I believe that we should be aware of that. We also know that there's been a huge shift of when it comes to social harms. There's been a huge shift in the ways content is being moderated by the big tech platforms, and there's this shift towards well, they're called differently. These models, which were not strict and which not they rely on independent fact checkers as professionals who have certain knowledge on the local context and who can provide feedback and correct information. So the extent to which harms exist, I believe, is today we do not actually know how big it is, but we know it exists and it can be huge. So yes, we do not, as far as I know, we do not actually have an exact calculation of harms and of risks that we are exposed to. In the countries such as mine, I'm not sure where you're from, Emina, but based on your name, you could be from Bosnia as well. I don't know. So yeah, as far as I know, there's no any study which relies on some sort of donut economy type of study that tends to calculate or to measure any degree of harms that we suffer because of AI or risks that we are exposed to. So unfortunately, I think this is something that we should deal with.
Thanks, Nasir. I am from Croatia, so not far away from you.
Ah, all right, neighbors.
Mm-hmm.
So thank you very much. Any other question? So I just have one question, is that you explained a little bit that on the European Union is trying to introduce some basics. And if you see, for example, it introduced artificial intelligence product liability directive instead of a regulation. So maybe according to your research in the future, is going European Union to introduce a regulation instead of a directive? Because when we see, for example, on civil liability, we see that at the member states, we have different rules. Yeah, and as I said, I'm not a civil lawyer, but when I studied, I remember that for the liability, a lot of efforts have been done to have a common code, something like this, but failed. Yeah, yes. So how do you see this? Because I remember when I started my PhD, it was antitrust damages directives and also dealing with such issues. And at the time said, okay, let's go with to have some basic rules. And then we will update for sure, but maybe after 10 years. So how do you see this? Because, for example, in Albania, if you know Albanian, you will see that every area now is occupied by artificial intelligence. We will do harmonization of legislation by artificial intelligence. We will do public procurement by artificial intelligence. We will do, for example, in medical sector, okay, by artificial intelligence, let's go to Israel and make a partnership with them. So, but as you said, we here is not discussed to what extent we are aware of the risk that we are exposed by artificial intelligence.
Well, actually, first of all, I think we are testing to two opposite trends, which is a bit paradoxical. So first, if you have an AI system and you're, for instance, a developer or deployer or user, you are subject to AI acts in the EU. You don't even have to be in the territory of EU because of its extraterritorial effect, right? So if you're a subject to the EU AI Act, you have plenty of technical standards to meet depending on the AI system in case. So basically, you have incentive not to be an AI, not to have an AI system. You want less regulation, less rules, right? At the same time, there's huge buzz around AI, and everybody wants to be perceived as AI company. Because if you have an AI product, then your product can be sold for higher prices. So companies are like in between nowadays. Should we try to avoid or not? Sometimes it is impossible, of course, but like there's some cases which are like on the edge, so it can be perceived differently. So your question about AI system and pervasiveness of AI system, I believe, is related to this buzz, because now we believe in this. We have this techno-optimism. As I said, there's normative optimism. There's also this optimism, which I believe is not based, at least not all the time, based on the belief that technology is going to save us. It is going to solve our problems. perhaps to a certain extent, but we, as in many cases, we could see that actually what the AI does, it replicates what it finds in the world. And I think this is actually the narrative which can be understood behind many examples of AI bias, when AI used to discriminate based on sex, race, gender, religion, etc. It did so because the world is imperfect. Of course, it did so because humans were not careful enough, and they designed it and trained it based on flawed data. However, the flawed data is the data which can also be found in the world. So do we want AI to be better than us? I think we do, right? But I'm not sure the way to do it is so easy. When it comes to the form of, so for those who are not lawyers, there's two types of legal instruments adopted by the EU. The one is regulation, the other one is directive. Both are binding, but in case of directive, member states have more freedom because they can adopt this instrument in their national in form of their national law, but they can modify typically they can modify certain parts of it, and in order to adjust it to its national system. Whereas in case of regulation, they need to apply it directly. For instance, the AI Act there's also this trend, which is interesting. The EU tends to name its instruments as acts. There's no such a thing, as far as I know, as act. This is Anglo-Saxon type of naming of legal instruments. The EU has regulations and directives. So for instance, the EU AI Act is a regulation, right? Okay, what I read, I've heard, so this is not something I'm certain, is that the question of regulation of liability was a matter of political compromise, because states didn't want to give up parts of their jurisdiction. Because if they allowed the EU to adopt more a comprehensive liability instrument, or a liability instrument in a form of regulation instead of directive, as it did, then it would mean that they lost a little bit of jurisdiction, and because of various reasons they were not willing to do so. Other compromises of similar nature can be identified in the adoption of EU policies in case of AI. For instance, the EU AI Act does not allow facial recognition in general. However, it makes an exception in some cases. And I mean, you can find it as reported by different news outlets. I think France was the state who advocated for this exception that would allow it to use facial recognition in some specific cases in law enforcement. So the EU law, I think, as always, has been a matter of compromise. And the setting, the constellation of powers constellation of powers in the EU currently was like that. And I cannot find any deeper explanation for why is it a directive instead of regulation.
Thank you very much. Any other question? Yes, Eleni. So I'm reading a question of Eleni. So do you actually believe artificial intelligence should strive to be entirely unbiased and natural, or should it be designed to reflect certain human values and ethical principles? How could we balance these two approaches?
Yeah, well, I'm not a computer scientist, so obviously I do not I understand concepts, I believe, but I'm not, my knowledge is not so extensive so that I can make some bold claims in this respect. What I think is that probably there's no such thing as flawless system. What we can do is instead we can limit the use of AI in certain areas that we find to be of high risk, and that we can be very cautious. And I believe in case of response from a state, that many things cannot be legislated when it comes to AI, and that we need to work on AI literacy and media literacy, and that prevention based on education of users, developers, deployers, and all those who participate in our society is probably the key. We can obviously adopt the rules and prohibit things that we find to be bad, but there's a great question of how to enforce such standards and how to identify whether AI system was sexist, racist, or whatever, right? So sure, I'm sure the incidents are going to happen. We need to fight them, but I don't think there is such a thing as flawless system in general, especially AI system, which tends to change over time based on its previous decisions, previous experiences, etc.
Thank you very much. Do you have any question? So thank you very much, Nasir. It was very nice and useful, this conversation, and also to reflect. And as I said in LinkedIn, when we discussed, that's this idea of your book, discuss furthermore research on the Western Balkans. And of course that we will be in touch, and let's extend your research, not only in Bosnia, but also in other Western Balkan countries. And also thank you very much other colleagues that participated, and of course Tina making this event possible.
Thank you so much for having me. I really enjoyed.
Yeah,
Thank you, Nasir. Thank you.
Bye.
Bye-bye.
Bye.
Bye. Thank you very much.